Subscribe to our channel, press the bell icon and never miss an update from Latestly.
It's important for us. Today, I was inaugurating a virtual initiative of the Orissa High Court. And this morning, one of the initiatives of the Orissa High Court, which Chief Justice Muralidhar has envisaged, is the launching of an e-custody certificate, so that every under trial and every convict who is undergoing a sentence of imprisonment would have an e-custody certificate tagged to them. That e-custody certificate will give us all the requisite data in relation to that particular under trial or convict, right from initial remand to the subsequent progress of each case. This will also help us, I think, in ensuring that bail orders, for instance, are communicated as soon as they are made from the place where they are communicated to the jails for immediate implementation. This is a very serious deficiency in our system, the delay in the communication of bail orders, which we need to address on a war footing, really, because this touches upon the human liberty of every under trial, or for that matter, convict who has got a suspension of sentence under Section 389 of the CRPC. So these are some of the very important initiatives which we need to pursue in the short term, in the short run. Government also being our largest litigant, we need to take the government on board, I believe. And one of the things which we are now providing is an open API. The open API is a mechanism by virtue of which the government can track the progress of all their cases in whichever court. And this does not apply only to the state government, but to all the authorities of the state government, including the Jilla Parishads, the Nagar Panchayats, the municipal councils, the municipal corporations. So they can track, they have a real-time virtual data about the cases which involve each one of their entities, so that they can track the cases and they can see whether those cases are being pursued by the persons who represent them. The virtual courts equally are a matter of utmost importance. To give you just one example, virtual courts have now been set up across the country in 12 states for adjudicating traffic challans. The Honorable Chief Justice gave us figures of Uttar Pradesh. Proceedings have been completed in 338,366 cases. Fine paid in 25,703 cases, and the total fine collected is 1 crore and 14 lakhs. Across the country, 99.43 lakh cases have been completed. Proceedings have been completed. Fine has been paid in 18.35 lakh cases, and the total fine which has been collected is over 192 crores of rupees. About 98,000 violators chose to contest the cases. Now you can imagine that for a common citizen who has a traffic challan to spend a day away from daily wages and go to a court for the payment of a traffic challan is not productive. On the other hand, if the virtual courts are dovetailed with a nationalized bank where a challan can be paid, it's a win-win situation for the citizen. It's extremely productive for the courts. For instance, in Delhi, almost 24 judges who are dealing with the courts of traffic challan cases have been liberated to do other cases. So the work of the bar has not gone down. Those judges can deal with other cases where their involvement is really required and not in these ministerial cases, which are really a waste of time for a judge when this can be done easily with the aid of technology. Now, when we talk of technology, particularly in relation to the High Court of Judicature at Allahabad, some figures we must bear in mind, particularly in the context of the criminal justice administration. Across India, I'll first give you the basic figure for the entire country. 2 crore 95 lakh cases, criminal cases, are pending in the district judiciary of the country, of which about 77.5% cases are more than 1 year old. 2.29 crore cases are more than 1 year old. In Uttar Pradesh, 67.35 lakh criminal cases are pending, of which 15,000, to be precise, 15,056 cases are more than 30 years old. Many criminal cases are pending as the accused in such cases remains absconding for years. For example, the oldest Sessions case where the accused is absconding is Sessions Trial 64 of 1976, which was registered on 29 January 1976 in the court of the District and Sessions Judge Gorakhpur. The case belongs to the Kent police station registered with FIR number 1299 of 1975. In about 7,520 cases, 7,520 cases, the accused is absconding or is not appearing. Now, we know as judges that one of the real reasons for the delay in the disposal of criminal cases, 2 reasons, equally important, is the fact that the accused remain absconding, particularly after bail is granted. And second, the non-appearance of official witnesses during the course of the criminal trial for recording evidence. I'm sure that is the experience of Brother Justice Bindal even in Punjab and Haryana, in West Bengal, and so is mine in the state of Maharashtra, and of course, as a former Chief Justice of the Allahabad High Court. Now, we can use information and communications technology. How can we do that? What we can really think of doing is this, and this is what we are working on presently in the E-Committee, which is that we can ensure police station-wise that we have a list of cases where the accused is absconding. We can then escalate this to every district so that the superintendent of police or the senior superintendent of police has the same data. So the SHO of the police station has the data of how many accused in his zone, in his police station are absconding. The same data will be available district-wise for every senior superintendent of police or SP. We will also escalate it further by providing that data to the Inspector Generals or to the Director General of Police. So in other words, we will have a graded hierarchy of responsibility so that ultimately the police machinery is also alive to and accountable for the service of summons. Second, the absence of official witnesses. I think we have to make a beginning where at least the testimony, the evidence of official witnesses is recorded in all criminal trials across the board, unless the judge thinks otherwise, through the video conferencing platforms. Taking these baby steps to resolve the crisis within the judicial system, particularly in the administration of criminal justice, would go a long way in assuaging some of the concerns which we have today.